Hi, I'm Maciek Zaremba with Sarasota for Sale over at Keller Williams, and I'm here with
Reid McCullough of McCullough Legal Services.
And today's topic of discussion is going to be about title defects. So, in a real estate transaction, one of the jobs that you do is double checking, making sure that the property a buyer is purchasing does not come with any title defects. Tell me a little bit about what happens when you do find some title defects.
Certainly, Maciek. So a title defect is something that happened before a transaction. Going all the way back to the root of title, I review the entire history of a property and I determine if anything has happened which may burden the buyer with problems, whether it is a code enforcement lien for rubbish or for building problems, whether it's an open permit, or even something as simple as a utility bill that was never paid off long ago. These things accrue time and interest, and oftentimes buyers don't anticipate coming to a deal with problems. So the first thing to do, just like Douglas Adams says, is don't panic. These things are all solvable, and sometimes some require more work than others. But the first thing I do is I reach out to the sellers of a transaction and I inform them of the defect, whether it's a building issue or a judgment that might be against the seller personally, or even a lien against the property. And I say, we're looking to clear this. What's the next step? And if they know about it, then they can provide information. If they don't know about it, then I reach out to the person that created the defect, whether it's the county for liens or permits, whether it's a judgment creditor, or even whether it's, like, for instance, in the extreme example of a foreclosing bank. And I say, we're looking to get this thing taken care of. And I determine whether or not they're willing to release their lien. And if they are, then I prepare a payoff or release or an affidavit that there is no lien in some cases. And I include that in the closing documents. And when the transaction closes, I pay any monies that are necessary and I record a release.
Okay, so that will eventually, essentially, transfer a clear title, which then is insured by title insurance. Is that right? So if something else comes up in the future, they have an insurance policy.
Exactly.
Okay, now does it ever happen that a title defect is found and it actually breaks the deal where it cannot be fixed?
It is very, very rare that a title defect causes an irretrievable transaction. I find, in the hundreds and hundreds of deals that I've closed, there has been maybe one or two that resulted in a failed transaction, and those transactions, that usually means that the seller didn't actually own the property they were selling.
Interesting. Interesting.
For 99.9% of the title defects that come up in a title commitment are curable, and that's why you have an attorney on board that knows how to do it.
Yeah, another benefit of using a real estate attorney to close your transaction. So great. Thank you so much for all that information, Reid. If you guys have any questions about real estate, you can give me a call. My name is Maciek Zaremba, and I can be reached at 941-888-SOLD. And if you have questions regarding real estate law, call Reid
at 941-484-9714.
Great. Well, Reid, thank you very much. You've been very informative.
My pleasure,
And if anyone has questions, feel free to reach out. We are really here to serve and help you guys.
Here to help.
Thank you.